Hi everyone, I'm going to talk about Court of Justice of the European Union. We mainly divided four categories: history, structure, jurisdiction, and challenges. Okay, let's start. Court of Justice of the European Union (CJEU), formerly known as the European Court of Justice (ECJ), is the highest court in the EU, a ranking national supreme court. Its mission is to ensure the law is applied in the same way in all EU countries, and its judgment can affect both member states and individuals. Also, it is a referee between member state institutions and individuals in dispute relating to EU law. And the following is history process of CJU. The ECJ was set up under the Treaty of Paris 1951 to implement the legal framework of the European Car and Steel Community (ECSC). When the European Community was set up under the Treaty of Rome 1957, the ECJ became its court. When the European Union was created under the Maastricht Treaty 1992, the ECJ's power was again expanded to cover the broader legal remit of the EU. The Lisbon Treaty 2007 again extended the ECJ's remit to include, among other areas, justice and home affairs, as well as renaming the Court of Justice of the European Union. Because of the dramatically increase in the number of cases since the institution was established, Court of First Instance (CFI) was set up in 1989 to assist by dividing the workload, and it was renamed the General Court in Lisbon Treaty. In addition to this, the Civil Service Tribunal was set up in 2005 to adjudicate in dispute between the EU and its service civic. All three courts are based in Luxembourg.
Composition, structure, and procedure of the Court of Justice of the European Union. The Court of Justice of the European Union includes the Court of Justice, the General Court, and the specialized panels such as the European Civil Service Tribunal. Firstly, the Court of Justice. The Court of Justice is made up of 28 judges, one judge per member state, and 9 advocates general whose duty to perform the tasks assigned to the court by the treaties. The secrecy surrounding the appointment procedure and the political nature of the appointments has been addressed by the Lisbon Treaty. The judges are appointed for staggered terms of 6 years, with a partial replacement of judges every 3 years, and they select their president by secret ballot. The Court of Justice procedure are written and oral state, and the written is the most important state. Secondly, the General Court. The General Court was created to lessen the workload of the CJEU. It consists of one judge per member state, and unlike the Court of Justice, it does not have the permanent Advocate General. Judges of the General Court are appointed for a renewable 6-year term following the advice of an expert panel. It also has written and oral proceedings at the Court of Justice. And the last one is the European Civil Service Tribunal. The European Civil Service Tribunal was created in 2004 to relieve the General Court of its workload by handling disputes involving the EU's civil service, and it consists of 7 judges.
Jurisdiction of CJEU or its activities come in 2 forms: direct actions and references for preliminary rulings. Firstly, about direct actions. All actions passed directly by CJEU. They can be brought about by various agents. Actions brought by individuals and legal persons, such as companies or organizations, are handled by the General Court and on appeal by the Court of Justice. Meanwhile, those by the member states and the EU institutions are usually handled by the Court of Justice, and there is no appeal process. Generally speaking, there are 3 types of direct actions. The first one is infringement proceedings, whose aim is to resolve violation cases to secure the member state compliance. Secondly, judicial review of the Union Acts. To ensure that the EU is under control, the review covers regulations, directives, decisions, and any other binding EU acts. Thirdly, actions for damages, where the CJEU decide on compensations for illegal activities of the Union institution. Another activity is making references for preliminary rulings. The enforcement of EU law is not a responsibility of only CJEU, but also the national courts. Therefore, in order for the national courts to follow the right directions of EU, the courts have the right to refer to CJEU for guidance on issues of EU law. The major aim of this activity is to clarify specific issues of interpretation and application of EU law. In this case, the relationship between the national courts and CJEU is cooperative and non-hierarchical. The activities have been regarded as instrumental in shaping the legal order of CJEU and its relationships with the member states.
However, the Court of Justice of the European Union also has to face with a number of challenges. There are three main problems that the Court has to address, which are EU enlargement, the financial crisis, and EU accession to the European Convention on Human Rights, which stands for ECHR. Firstly, about EU enlargement, which led to the appointment of several new judges to the Court of Justice from countries with very diverse legal tradition. It also led to a large increase in the cost workload. Therefore, to deal with this problem, the Court has to develop mechanisms to ensure that the composition of the chamber includes a balanced number of more experienced and newly arrived judges, 12 new judges in detail. The members of state government are likely to agree in doubling the number of judges, up to 56, to handle heavier workload. The second one about the financial crisis in the Eurozone. Despite being an intergovernmental treaty, the Treaty of Stability, Coordination and Governance in the Economic and Monetary Union, which commits EU members to balance budgets to make all members of countries satisfied with the fiscal and welfare policy making. Hence, the Court had also ruled on the compatibility of the European Stability Mechanism, the EU's Permanent Rescue Fund, to cope with the issue. And the last one, EU accession to ECHR. According to the Court, the agreement to join ECHR undermines the autonomy of EU law, doesn't coordinate the level of right protection between EU Charter on Fundamental Rights and the ECHR. Just, it requires ratification by all EU member states and the member states of the Council to Europe to balance the legal and political arguments. European integration needs the CJEU judicial support to offer legitimacy and consistency to the process. We will just finish our presentation. There are four main parts that we show you today. Firstly, history of the CJEU. The second one about structure, and the third one jurisdiction, and the last one challenge. So I hope that all of this information that we demonstrate to you today will be very helpful to you. Thanks for listening.